And I'm joined now with Blaine Jones, our WPXI legal analyst. You were in the green room as this verdict came down. What was your first reaction?
In real time, as I watched the reaction, Lisa, I was not surprised. And it pains me to say it, but to a certain extent, I almost feel as though the trial itself was a bit of a formality. And the reason why I say that is because a trial of this magnitude, which has garnered local, national, regional, and international attention, I think all of us, we saw the video, and I would love to see the person that didn't form an opinion about that video. So, the prosecution did a very good job of laying out their case. The defense did the best they could. But quite frankly, I think that the trial was a formality, and Mr. Chauvin was guilty in the court of public opinion months ago, and that translated to the court of law.
Well, wait a minute. So if I'm Derek Chauvin's attorneys, I'm going to say I'm going to use that as the basis of an appeal, that people had already made their minds up and he didn't have a fair hearing.
Yeah, in the real world, that sounds great, but in the legal world doesn't always reconcile cleanly with the real world. It's not that simplistic. It's multi-layered. In other words, you have to have legal grounds for an appeal. Whether or not something happened that was against your rights. It's not as simple as this trial has been broadcast everywhere, I want a new trial. Now, the one ground for appeal that the defense raised yesterday that I think is extremely interesting is the fact that the judge did not sequester the jury during the trial. The judge sequestered the jury during the deliberation. Sequestration is basically, it's a theoretical vacuum. In other words, the people are in a bubble. They can't have any outside influences influencing their decision. The judge did not do that, and I think that could possibly be a grounds for appeal, although I'm not sure that alone is enough.
So we're talking, he was found guilty on all three charges. How much time does that translate to actually prison or jail time that he could be looking at?
Yeah, it's a great question, and at this point in time, it is 100% in the hands of the judge. And the reason is this. There are two types of sentences. There's a mandatory sentence, which the judge has no discretion over, and then there's a discretionary sentence, which is up to the judge. The three counts that Mr. Chauvin was found guilty of, they don't carry mandatory life. They have numbers. I believe the most serious charge, the second-degree murder, carries a 40-year maximum. So the judge a pre-sentence investigation was ordered. That's a background check on Mr. Chauvin. Presumably, he has no record, but then they'll take other factors into account, the trial, what the judge saw, so on and so forth. And also the prosecution asking for an aggravated sentence. So to answer your question, Lisa, I do believe that Mr. Chauvin will get what I refer to as life by numbers. What I mean by that is I believe the judge will give Mr. Chauvin significant time, and he will probably run that time consecutive with at least one of the other charges. As a result, Mr. Chauvin's in his late 30s, early 40s. I don't think we'll ever see him out on, I think he'll be behind bars forever. Wow.
Okay, so a last question. If he were your client, would you have him take this stand, or was that too much of a gamble or a risk?
Once again, we have the theoretical underpinnings of the Fifth Amendment, which says that you have a right against self-incrimination, and then you have to somehow reconcile that with our natural human instinct to want to hear the accused fight for themselves and hear what they have to say. I would have said to Mr. Chauvin, you have an opportunity to control the narrative about the video. Why not tell the jury what you were thinking? Because quite frankly, you have to hit a grand slam on this one because the video is overwhelmingly against us. Tell them what you were thinking. He chose not to. That's his right. His lawyer and Mr. Chauvin, they know the case better than anyone, but I think it was a tremendous risk not to take the stand, to tell the jurors what he was thinking in that moment, and to potentially narrate the video.
Some people were saying that he looked really stoic when he was throughout all of the criminal proceedings, and that the only thing you're left with is that video where he's kneeling on George Floyd's neck, that it wasn't a chance to humanize him because he never took the stand.
Yeah, and I don't think that's fair because, he's wearing a mask because we are in a pandemic. So when you're wearing a mask, all you can see is a person's eyes. So to say that a person is stoic and not showing emotion, I don't think that's necessarily fair. In terms of Mr. Chauvin not taking the stand, as I mentioned a moment ago, I think that was a miscalculation. I think that you say to your client, this is for all the marbles. You have to take the jurors inside your mind on that fateful day and let them know what you were thinking.
Yeah, at least for now, we're turning a page on this. We still have the other three officers, though, who are facing charges.
Yeah, and I was surprised that none of the other officers testified against them. We call it turning state's evidence. I was surprised about that. Perhaps the state wasn't interested in that, the state being the prosecution. But if I'm the other attorneys, I'm on the phone to the prosecutors the moment the judge said guilty, and I'm trying to get a deal for my client. I was surprised surprised that Mr. Chauvin didn't take a deal, because we all had an inkling, although you never know with juries, we all had an inkling where this might go. If I'm their lawyers, I am calling, I am emailing, I'm faxing, I'm getting in touch with that prosecution to see if we can work out some type of deal.
All right, Blaine Jones, thank you for spending time with us, really breaking it down for us. Always appreciate your time.
Thank you, Lisa.